minutes of the meeting from March 10th, 2025. Commissioners, any comments or revisions to the proposed minutes of March 10th?
I'd move to approve them as written.
We have a second?
I'll second.
All those in favor of approving the minutes of March 10th as written? Aye.
Aye.
Any opposed? I think it sounds like we passed. Okay. And the second set of minutes is from the meeting from March 24th, 2025. Same process, commissioners. Any revisions or comments to the minutes as written? Do I have a motion?
I'll move to approve those of the 24th as written as well.
Okay. Second?
I'll second.
All right. All those in favor say aye. Aye. Any opposed or abstain? Okay, great. Thank you. Okay, that brings us to item number 5 on the agenda, public comment. Iris, is anyone here that wishes to raise an issue or public comment on items that are not on the agenda?
No.
Great. Thank you. Okay. Item number 6, the Commission for Citizen Involvement and the general updates. Apologies, I think we actually had one, but I didn't get it printed out for the Westlake Neighborhood Association, and I'll give you the details in a second. All right. Okay. The Westlake Neighborhood Association, the 2025 annual board meeting will be held Tuesday, April 29th at 6:30 p.m. and the location will be the Oak Creek Elementary School Library. On the agenda will be welcome introductions, new business regarding the school district ballot and the Lake Grove Elementary rebuild. And then I believe there will be an introduction of candidates for the board of directors for the neighborhood association. Okay. And we're gonna, that was item 6. We're gonna add an item not on the agenda. We're gonna call it item 6.1. And we'd just like to introduce the newest commissioner to the planning commissioner, Mr. James Bruce. Welcome. Thanks so much for being here and appreciate your time and efforts.
Thank you, and I'm excited to be here and look forward to giving back to the community. Thank you.
Okay, and item number 7, work session. Today's work session will be on the home occupation standards. It's LU 25-0002. This is our second work session on the home occupation standards, and we're going to review and provide input on the draft amendments to the standards in the CDC regarding home occupations. We'll also receive the results of the recent survey, I think, that we discussed in work session 1. I think staff coordinator, Mr. Michael McNamee, will take us there.
Thank you. Good evening. So yes, this is a follow-up work session on the potential code update to the city's home occupation standards, which staff previously discussed with the commission in January. The focus of this project is to replace one of the criterion in the home occupation standards, which says that the home occupation use can't alter the residential character of the neighborhood or infringe upon the rights of residents in the vicinity to the peaceful enjoyment of the neighborhood. The reason staff have targeted this standard for replacement is because the concepts of neighborhood character and peaceful enjoyment are difficult to define, which makes them hard to understand and enforce. Goal of this process is to hopefully replace subcriterion 1 with a new set of standards that are measurable and clear so that the public, home occupation owners, and city staff can easily understand what's expected for home occupation businesses. To get to this point in the process, staff has performed research into home occupation regulations for peer jurisdictions, mostly other cities in the Portland Metro or Willamette Valley, to help provide a starting point for potential new regulations. We also took a lot of input from code enforcement staff at various points during the process. Staff presented to the Neighborhood Chairs Committee at their meeting on January 18th, where we got some initial feedback about the project. The Planning Commission had a first work session on this project back on January 27th, and the Council had a work session on April 1st. That input helped form the concepts that will be presented here today. Staff also sent a survey to all active home occupation license holders asking them about how well they understood and how big of an impact existing and potential new zoning requirements would be. After today's work session, there are several tentative dates scheduled for this project. Staff will have another work session with the Planning Commission on June 9th. Then draft code amendments will be presented to the Commission at a public hearing on July 14th with potential findings on July 28th. Staff will then present the Commission's recommendation to the Council at a public hearing on September 16th. So based on Pierce City research and feedback from the Neighborhood Chairs Committee and code enforcement staff, we previously discussed 4 possible big picture concepts for replacing subcriterion 1 at the last work session. These were limits on noise, emissions, and similar impacts, limits on client visits and commercial vehicles, limiting or banning modifications to the dwelling where a home occupation occurs, and requiring all business activity to take place inside of a building. After the Commission provided feedback in January and staff performed further research and held more discussions with code enforcement staff, a slightly modified set of concepts was presented to the Council on April 1st. And I'll go through each of these in more detail. This is the list as it was presented to the Council, but some of the concepts have been refined or removed based on the Council's feedback. So first of all, one idea could be to limit the number of clients who are permitted at the dwelling at one time. This would help to limit activity at the home occupation at a given time, addressing 2 of the biggest complaints neighbors tend to have about home occupations, traffic and noise. Limiting client visitation in some way is a pretty common regulation among peer cities, and enforcement suggested basing the limit on the total number of clients at the dwelling at once rather than regulating the number who could come over a certain period of time, because that would be easier to enforce. When staff discussed this with the Council, they were generally comfortable with the idea, so this was left in the draft code amendments. In the potential draft code language, staff has proposed a limit of 5 clients at once. The specific number of clients was initially proposed as a placeholder number for the survey. But even so, most of the survey respondents did indicate that they could comply with the 5-client limitation, with some exceptions. Staff would like to ask if there is any additional information that the Commission would like to consider before establishing the maximum number of clients allowed to visit a home occupation business at once.
I have a question. Would Airbnbs be considered a home occupation business?
They would be. They have a kind of subset of regulations that are in the home occupation standards.
If we went back to that first slide with the larger set of home occupation standards, you'll see number 7. There are additional criteria that apply to short-term rentals, which is essentially an Airbnb. So we do require them to have a business license and to register as a home occupation, but they are subject to additional criteria.
I could see 5 at a time kind of being a little on edge with Airbnb, especially with larger properties that have multiple bedrooms.
Well, I don't think it would limit, that's a good question. That may be something that we need to clarify because they aren't allowed to have special events. So for instance, if you had an Airbnb, you wouldn't be able to have a party there where you're, charging people to come or whatever, or actually you're not supposed to hold parties or events. But yeah, if a family is large, they should be able to rent an STR without that limitation. So that's a good feedback, and that's something that we should consider when we're writing up the standard.
Thank you.
Yeah, if I could jump in, is there a proposed definition for what client means?
I mean, we aren't proposing a new definition for client, so no, we could get into a little bit more detail on that. I think if you recall, even in the proposed language, we said clients or people accompanying clients, even to make it more enforceable, really, because it's hard to differentiate between a client and somebody else that might be at the property. So that was one way that we attempted to sort of eliminate the sort of issues with defining who is and who is not a client, I suppose. But, we are open to input
Yeah, I think my concern would be if the quote-unquote client to the business is a corporation, like, and shows up with, 4 employees, is that 4 individuals to the 5 cap, or is that just one client, even though it comes with four employees? I feel like it's similar to Commissioner Najak's concern about the numbers.
I agree with that assessment.
Yeah, I think, again, we attempted to write it as though, it's just the total number of people essentially visiting the business. So that would be, the idea is that it would be the total number of people, not just,
Okay.
clients specifically.
Thank you. All right. So moving on, the city could also place a limitation on the number of commercial vehicles associated with a home occupation. For ease of enforcement, staff suggested basing the regulation on visible logos or commercial markings. At the council work session, council members provided direction that they would like to see the limit applied only to vehicles that are parked off the property, which is reflected in the draft code amendments provided to the commission. Staff is looking for direction from the commission about the number of vehicles permitted to be parked off the property. In the survey, most respondents said they don't park any commercial vehicles at home, but of the ones that do, most say they have 1 or 2. In the past, code enforcement has encountered outlier cases where a home occupation business has 3 or more non-personal vehicles parked at home or near the home.
Does off the property refer to like on the street?
It could be, yeah. Just not on the property where the home occupation is located.
So it could be at another location entirely?
Well, I guess that's a good point. I think the intent was to capture adjacent, vehicles that are parked off the property, but it is kind of difficult to start to define that. So we could say in the right-of-way or something, within the public realm, limited to that potentially to sort of further define, if they had a neighbor with a parking lot or something that allowed them to park there, I suppose we would be okay with that.
That's the intent there, is just basically, on the adjacent street vicinity. I see. Thank you.
That was the intent, but I suppose there's more clarifying language that we could provide there.
Are these issues actually taking place, and you're surveying to see whether or not they're acceptable or not, or are these just proposed possibilities?
These are coming from, so our code enforcement officer is kind of helping consult on this. And these are kind of typical issues that we see with home occupations. So that's where these came from, the sort of typical complaints that we tend to receive.
Do you have any examples of those?
Well, we had a business who did like a house cleaning type business, and they had sort of vans, sort of larger vans, multiple vans, some parked on the site, some parked on the street. That has been an issue. So that's an example. I mean, I'm not going to call out a specific business, but yeah.
Is that the reason why logo is mentioned in here?
Right, because that's the only way we could really determine if it's someone's commercial vehicle. If it doesn't have a logo on it, we don't know if that's a personal vehicle. It's not really enforceable. So we would have to rely on that. And I think the issues that most people have is people with larger vehicles like big vans, and they have their logos on it, and they're kind of parking all over the neighborhood, and there's several of them, and that starts to infringe on the neighborhood character. And so that's what we're trying to capture, recognizing we're probably not going to capture everything.
So would it be up to us to limit the vehicles and so forth like that, or is this just something that's recommended?
Well, our recommendation would be to apply this limitation, I suppose, as a substitute for that standard that we currently have that's fairly broad, where it's just talking about the peaceful enjoyment of the neighborhood and, the maintaining residential character, that type of broad language, that's sub-criterion 1. So this is one of the ways we're hoping to make that objective, that's fairly subjective language that exists in the code today. And you can see it's difficult. We are talking about these visible logos because that is something that is objective, that we can actually count, that our code enforcement staff in the field can easily identify, document that, as opposed to having to run license plate numbers or kind of infer something about the nature of a vehicle parked on the street. So I think, we are trying to come up with ways that we can draw a line somewhere that is enforceable.
And city council's direction was that there's no limit if they're parked on the home occupation property. This is just parked off the property.
That's right. Yeah, and I think they said they would allow one vehicle to be parked off of the property, I guess, at maximum for the, related to the business. So
And not to sort
they
of,
would prefer that, rather, I guess.
not to get ahead of ourselves, I don't know if there's other discussion of this, but the examples that we heard, as you were bringing up, Jessica, were primarily, I remember the examples we had basically were a lot of vans all leaving at once in the morning, and the other one that I recall was like a pool party business where it was like a pool party every day. And so dealing with the vans, was there any examination of maybe of trying to target vans as a vehicle type objectively?
I'm not sure. I mean, I'm not sure, Michael, if you have any background on that, but I could think of reasons why we wouldn't want to necessarily use all vans as a catch-all. We might, be catching a lot of non-home occupation related activity, and that might make it difficult to actually determine whether a van is actually tied to a business or not. But yeah, I don't know, Michael, if you have any other thoughts. Sorry.
Yeah, I think based on the feedback that we got from code enforcement, it just would be hard to capture.
And there's some people who have construction businesses. So, what we don't want is people like storing their whole fleet of vehicles, in their, but we also want to be flexible because having a home occupation is a really important business incubator. It saves folks a lot of money. It allows people to have a livelihood and still, that's still compatible with the neighborhood. So I think that the council just wanted us to be careful not to go too far. I think, it's a good point. Yes, vans tend to be more impactful, but you could have someone with, a huge, big, I don't know, F-150 truck, and they've got 5 of them or whatever, and it's commercial, so it's not just vans. So, or you could have someone who's got some sort of a ride share business or something like that and could have a several cars or limousines. I mean, there's lots of different kinds of vehicles.
I'm envisioning where, something that probably would be relatively well targeted toward commercial activity. Like, okay, yep, limit the number of, logoed commercial vehicles, off-site, that makes a lot of sense. But, we could see a lot of the same issue if someone's parking, a fleet of 6 commercial vans on-site and then leaving every morning. And, would it be reasonable to say, max 4 vans on a property? Maybe. So, just something to consider maybe.
Yeah, I think, but it's certainly a good thing to think about. Obviously, things that are parked in a garage or, that aren't visible are different than things that are visible in terms of neighborhood character, et cetera. So we might want to think of that. But yeah, just to kind of reiterate what Jessica was saying and what we heard from council, there was a bit of a push and pull between folks that wanted to make sure that we didn't want to, run into these issues and wanted this to be enforceable and to maintain the residential character, but also folks that were really concerned about impinging on the rights of folks to run their businesses and, acknowledging, a lot of folks have sort of a, side business or, a lot of reasons to have, sometimes more than one business that's operating on their property. So we don't really want to get in the way of that as a city either. So really, we're trying to land somewhere in the middle with this and not be really leaning too far in one direction. But as you'll, I'm sure, see, it depends on the issue here. So there's certain things where we did land on maybe a little bit more of a regulatory approach there. But.
Is there currently any kind of restriction on this issue?
Yeah, so we currently have that subjective criteria, that's sub-criterion 1, as we've been calling it, where it is that really loose language that we've had a lot of difficulty enforcing, and that's kind of why we're getting into this project in the first place, due to some of the difficulties that have arisen so frequently, and the direction that code enforcement staff receive from City Council related to some of those issues. So, yeah, we do have some language that is extremely subjective. It doesn't talk about, commercial vans or commercial vehicles specifically, but it is about the character of the neighborhood and maintaining that residential character as opposed to commercial. So we're trying to kind of define that a little bit more specifically with this project.
Is it categorized under the nomenclature of being a nuisance? Is that what it is?
No, it's actually a different portion of the code. It's just the use-specific standards for home occupations within our community development code, as opposed to the larger sort of city code that would govern nuisances.
What would be the governing power over that? I mean, would you call the police or would you?
Well, with these, I mean, we have code enforcement staff that goes out and enforces these types of complaints. I think particularly with the noise regulation that we're talking about, that might, we're proposing that would change and be more of a typical sort of nuisance complaint that would be handled by the police. But for the most part, these use-specific standards are intended to be easily enforced by code enforcement staff, yeah. In the field, and I don't know, we have Bill in here for a lot of the presentations. He's not here today, but he has a good track record in the public of trying to really work with folks and avoid issuing violations or really going too far with these. But it is sometimes it's inevitable, and so we were trying to kind of find a little bit more definition for when things have to go to that sort of violation route, and trying to come up with some clear and objective criteria that we can point to when we are in need of actually issuing a violation. I don't know, Jessica, if I explained that correctly or if you have anything to add.
Yeah, he's absolutely right. Our main objective is to get compliance, voluntary compliance, before we resort to issuing a violation or a citation, and that eventually goes to court. So, yeah, I mean, I don't really have anything else to add other than the current criterion, meaning that it can't, basically infringe upon the neighborhood character or enjoyment of, the neighborhood. That is just too broad. And so what we're trying to do is come up with things that are sort of proxies for that, so that we have something that both businesses and neighbors can understand, helps us determine when a business is infringing upon the neighborhood character or enjoyment of the neighborhood. So that's what we're trying to do. So the vehicles, the number of clients, all the other standards, that's what we're trying to get at, and trying to make these measurable and objective so that they're more easily understood and enforceable.
Do you have any examples of this, though? I mean, it's pretty hard to picture what it would be like just, if you had 3 vehicles or 5 or whatever. Do you have any kind of examples where you've got a home business there with commercial vehicles parked up and down the driveway or out on the curb or something?
Well, I mean, we don't want to target any particular businesses. And so, we didn't bring any photographic examples, but when Bill Youngblood, who's our code enforcement officer, was here at the last study session, he talked about some examples of this happening. And the one that sticks out in my mind was the cleaning business, where there was several vans that were coming in at once and parking on the street, et cetera. But, I'm sure there are a number of other examples out there. Happy to provide you some more examples if you like. I would say that it is not the most pressing problem, but it is difficult when it arises, which is why we're trying to address it. So I wouldn't say that this is the most frequent complaint that we have, but when it does come up, it's really hard for us to enforce that, because we can't tell someone, well, you've got 2 vehicles, that's okay, but 3 is not. There is no set objective number. And so this will make it much easier for everyone to understand when someone has crossed a line.
Okay.
Jessica, sorry to interrupt. What would you say is the most frequent type of complaint?
That's a good question.
For code enforcement?
Signs are a big complaint for neighborhoods. That's a big one. Noise is a big complaint. Sometimes we get complaints that there are outside employees that don't reside at the dwelling. You'd done some research on the complaints, or you had some in your prior case, or prior, reports to the PC? I just don't remember off the top of my head.
Bill gave me his list of examples over the last 5 years, and unfortunately, I don't have them in front of me, but.
I would say overall, home occupation complaints are not our most frequent complaint, but they can be the most difficult to deal with when they come up because of this. It's such a broad and subjective standard. So in terms of enforcing it and closing them out, they're some of the hardest to do.
Of course, code enforcement doesn't just deal with home occupations. They deal with complaints of many different types. So this is, often related to building permits and construction activity as well, where, perhaps some work is happening that's unpermitted or something like that, and they'll go out and there's a pretty quantitative and thorough set of codes and criteria that you can use and say, look, you haven't been issued a permit, you're not supposed to be doing construction. It's pretty easy to fall back on that, but when it comes to this squishy subjective language, it's a lot harder to sort of discuss and enforce in the field and sort of handle it when the situation arises. And of course, we don't have anything like the uniform building code to lean back on with this, but it is something we are trying to improve.
Does a person that's starting a home business here in Lake Oswego have any obligation to come to the city and report that?
Yes, we require a business license for all businesses, including home occupations.
And that has to be renewed once a year? Yeah. Yearly, yeah.
How would a person know that? How would they be advised about that?
Well, that's a good question. I mean, it's typical for cities to require business licenses. So I think a lot of businesses do know that. But I'm sure there's a lot of businesses out there that are probably operating without a license, and that is a common thing. And that's something, if we come across it, if we get called out for a complaint, we will check and see if they have a business license. And if we don't, then that becomes part of the correction and hopefully does not rise to the level of violation. So we'll say, in order to correct this, you need to apply for a business license by such and such date, et cetera. But yeah, it is something that we have on our website. So we have if you go to our main webpage, we have a link for businesses, and so it does talk about the requirements for businesses in Lake Oswego. You also have to get sign permits, and other types of permits might be necessary to open up a business in the city. So we do have resources on our webpage about that.
Okay, and once again, I just want to get some clarity here. How is that enforced, if at all? Say you got a complaint or just a police's car's driving by and sees this activity going on and thinks, hey, I wonder if there is a permit for this business. Do they have are they the enforcers of this?
In general, well, it depends on the type of complaint. If there's a noise complaint, that can be something that the police will come out and do, or if they're parked illegally, the police will go out there. But if it's just a complaint that we receive that someone says, hey, somebody's operating a business, I don't think they have a license, or I don't think the business is legal, or they have a big sign out there and we think it's too big, our community development department code enforcement staff will go out and investigate those. So the police do get involved or can get involved, but for most of these types of complaints, it'll be the code enforcement officers.
Are we okay with continuing?
Were you looking for us to sort of give direction, like go with one vehicle, or are we not at that point right?
I would say we're not at that point unless you want to be. But I was hoping maybe we could go through the presentation, then we can come back to the, okay. All right, so next idea. The city could place some sort of limit on outdoor activities associated with home occupation, specifically business activity. Outdoor activities have the potential to impact both neighborhood character and peaceful enjoyment. Staff didn't make this clear during the first work session, but since dealing with complaints about this, the city has a standing internal policy to not allow outdoor business activities. This is currently enforced based on complaints. It's not explicit in city code. At the council work session, council members directed staff to include a ban on all outdoor business activity because they felt that was in keeping with the spirit of a home occupation. So that's what's in the draft code amendments. Before the next work session, staff will research and refine possible exceptions to this rule for cases where outdoor activity wouldn't have an adverse impact on neighbors. For example, a commercial artist painting in their backyard, that sort of thing.
I have a question on outdoor activity. Sure. If exceptions would be considered as well for people who might have like a landscaping, home propagation business, or also like a farming, agriculture related business. Someone's harvesting things in their yard and producing goods.
Yeah, I think, sorry, as Michael's writing here, I'll just mention we actually already within the home occupation standards permit some outdoor sort of storage of vegetation. So I think there are some inroads that would suggest that we would be okay with allowing that type of activity. So that is the type of thing that we'll be prepared to talk a little bit more about at the next work session, some things that would make sense to accept from that. And I think the types of things you're mentioning are certainly on that track. When it comes to the sort of agricultural piece, that's another kind of, that's a whole other conversation, I guess, that Michael will talk about a little bit as related to the sort of winery and farm stands kind of use. So, you know, I think there's questions of scale and how we might consider those. But, you know, we have some different ideas, I guess, to govern those.
I think you might also want to consider like religious or spiritual exceptions to that, so you're not infringing on somebody's constitutional rights.
Are there any other questions about or comments on this idea? Okay. Okay. Noise is one of the impacts code enforcement gets complaints about frequently in relation to home occupations. So staff presented the concept of banning or otherwise limiting electric-powered speakers to the council. However, the council felt it should be enough to rely on the city's existing nuisance ordinance, which already lays out limitations for noise impacts between properties. To make it clear to home occupation applicants and the public that these rules should be followed, staff suggests adding a reference to the nuisance ordinance in the home occupation regulations. Staff also presented the idea of banning deliveries from tractor trailers to home occupations based on the experience of code enforcement, where they had cases of large trucks that were blocking public streets or access to abutting properties. However, the council expressed skepticism that it would be practical for home occupation owners to be able to control the type of vehicle where deliveries were coming from, and directed staff to remove this concept from the draft code amendments. Flag lots can have unique issues when it comes to home occupations, since they tend to abut more properties and often use shared access lanes. Because of this, code enforcement suggested placing additional limitations on flag lots to address this concern. But the council expressed concern that limiting home occupations on flag lots could result in disparate impacts for home occupation businesses on such lots, and conveyed that they did not want to be overly punitive towards such business owners. Based on those concerns, council directed staff to remove the flag lot concept from consideration for the draft code amendments. Finally, code enforcement suggested adding hazardous materials restrictions to the home occupation use standards to make it easier for them to enforce on issues that involve these materials. Among peer cities, it's common to ban or restrict the use of hazardous substances for home occupations. In the draft code amendments, the language references the definition of hazardous materials already in the definitions section of the Community Development Code, which in turn refers to the definition provided in state law. In doing research and outreach for this project, staff identified some uses that might currently operate as home occupations, but could be more appropriate to regulate as separate uses. So ones we identified were both agricultural uses, farm stands, and wineries. They're both uses that can be appropriate in some residential neighborhoods, but might have more impacts than a typical home occupation. For example, they may take up a lot of outdoor space, require later operating hours, or attract more customers than a residence or home occupation. So the city could look into whether it would be appropriate to regulate these as permitted or conditional uses in some residential zones. Since there are some existing businesses with home occupation licenses currently, staff would suggest including this with any update to the home occupation use standards. And council did provide direction to staff to continue looking into this issue, including expanding the idea to include agricultural uses that are similar to wineries. Staff will bring back draft code to the commission in June after we've been able to research and refine language internally on this. Okay, so to close, I'd like to briefly discuss the results of the survey that we sent to home occupation license holders. This was a short survey we sent at the end of February, which was open for 3 weeks. It had 4 sections. The first asked for some background information about the business. Then respondents were asked to rank their level of understanding and ability to comply with existing specific use standards and proposed code concepts. And then finally, a general feedback form was provided. In the background info section, we confirmed that the respondent had a home occupation license in Lake Oswego and asked about the type of business. The answers generally reflected the overall breakdown of active home occupation licenses, with a lot of respondents providing some sort of professional service in a low-impact way. Businesses that might have a bigger impact on the neighborhood were not widely represented in the sample. This partly reflects the overall makeup of home occupations, but also might be a self-selection bias, where businesses that were afraid they might be violating current city policy might not have answered the survey for fear of bringing enforcement action. Respondents were asked whether there were any non-personal vehicles parked at the dwelling. About 8% of respondents said they did, but most of those people likely interpreted the question to mean client vehicles rather than commercial vehicles based on their responses, their written responses. The staff estimates probably about 1% of the overall sample indicated that they have a commercial vehicle parked on site. We also asked if home occupation owners saved money by operating at home, and if so, how much. An overwhelming majority said they did, with most saving $1,000 a month or more. This suggests home occupations are important for supporting business enterprise, especially small or newer businesses that might not be able to shoulder the cost of maintaining a brick and mortar location. In the next section, respondents were presented with a selection of the existing specific use requirements for home occupations, and then asked to rank their level of agreement with the following statements. I understand what actions I would need to take for my business to comply with the standard, and complying with this requirement is or would be a burden on my business. So this chart shows the average level of agreement, with criterion 1 is circled in red. When asked if they understood the standard, the average response was a 4.42, which is in between agree and strongly agree. This might reflect the fact that most home occupation businesses are low impact. A business that involves only a home office with no outside client visitation, is generally not testing the limits of neighborhood character or peaceful enjoyment of the neighborhood. As a result, even an ill-defined standard might be easy to understand for owners of lower impact businesses. Lower impact businesses are also less likely to have experience dealing with the ins and outs of applying the standard, since this typically arises during the enforcement of activity reported through the existing complaint-based system. Regardless, out of the 4 existing requirements that respondents were asked to rank, subcriterion 1 performed the worst, which indicates this is still the weakest of the existing standards. As far as the level of perceived burden, all of the existing standards scored between strongly agree and disagree when respondents were asked if complying with the requirement would be a burden to their business. The next section asked about the potential concepts for replacing subcriterion 1 with the same prompts to agree or disagree with. The survey was sent out before the council work session, so it includes concepts that have since been changed or removed. So this chart again shows the level of agreement for each of the potential concepts when respondents were asked if they understood them and if they would be a burden to their business. All of the concepts but one scored better than subcriterion 1 when it came to the understandability, even though the difference was relatively small because people also found subcriterion 1 easy to understand. The level of perceived burden was also similar to the existing requirements, with an average score between strongly disagree and disagree for all the concepts but one. The one that did not score as well as the others had to do with flag lots, but that concept has since been removed from the draft code amendments. At the end of the survey, respondents were given an optional form to provide general feedback about the project. About half of the respondents filled out the form. Their responses ranged in tone, with some being supportive of the project overall, some expressing skepticism, and many warning the city to be careful about imposing new restrictions on businesses without carefully considering the impacts. Okay, so as mentioned, here's the tentative schedule for the rest of the project. Staff will bring this item back to the Planning Commission for a third work session on June 9th. After that, staff will present a draft of code amendments to the Commission at a public hearing on July 14th, and then bring the Commission's recommendation to the Council at a public hearing on September 16th. That concludes my presentation. Thank you.
Thank you. I have a question. Does the home occupation license apply to in-home care, such as in-home childcare or in-home care for seniors, people with disabilities? I could see some of these having issues with sort of outdoor usage or number of vehicles at a time, picking up and dropping off kids, that sort of thing.
So you can correct me if I answer the wrong way. My understanding is that they have to get a license, but there are state requirements that make it so we have to treat them differently. So for home daycares, for example, the state law says that we can't apply restrictions that would be more than what we would apply to a residence. So if we added additional restrictions to the home occupation ordinance, they wouldn't apply to a daycare, for example.
Great, thanks for clarifying.
I understand one of the main concerns of looking at this issue was that the subcriterion 1 was vague and hard to enforce. My kids go to a art camp that's a local art camp where I think the lady has 4 to 8 kids in the art camp at a time. I'm pretty confident none of the neighbors care or think it's fine that she runs the art camp. So picture a situation where there hasn't been any complaints. I'm concerned, has any analysis been done on the potential chilling effect for businesses that no one in the neighborhood has ever complained or would plan to complain, but if we come out with these restrictions, people want to follow the rules and comply, and there could be a chilling effect on otherwise non-impactful businesses, such as the one I gave the example of. People want to follow the rules, so they're going to restrict their options. So I'm just curious if there's been any analysis on the potential chilling effect on business, whether that outweighs the increase in enforceability.
Yeah, I will say that was one of the purposes of the survey, was to get a sense from people whether we were kind of going too far with any of the concepts. And as far as whether we've done any specific analysis, we haven't. It's definitely been something that we have considered, and we're hoping you all will consider when you give us your feedback. But we don't have like data that we've gathered or anything like that. So.
Yeah, it's kind of, I mean, again, the survey, as you were just pointing out, was our way of trying to identify that. But I think, as you also pointed out, there's this kind of self-selection of who's going to fill out the survey, and the sort of things that you're proposing are not likely to come up in a survey where, you might just be kind of flagging yourself for enforcement issues later down the road or something. So, I think that's really another reason why we've flagged, those potential exceptions, potentially for the outdoor activities rule in particular, to think about businesses that we could be precluding, that this could have a chilling effect on, that we would not necessarily want to do that for. So I think that is something that we intend to analyze in more depth before the next work session, and part of the reason that we did want to do another work session, in addition to talking about the agricultural sort of farm stands and wineries uses, which, I mean, similarly, those would have been precluded by the standards. And that's why we identified them as like, hey, we need to look into this and figure out, a different strategy. So, yeah, I think that's constantly something that again, it's this balance, and I think we're going to try to do what we can to identify those businesses that could have an outdoor component, that we could be sort of, contributing to this sort of chilling impact. But yeah, I think with the number of people, that's another thing where it's just like, I'm not sure what data we should be looking for to make that, to draw that line. And so, you could think of it, obviously one advantage of subjective criteria is you can actually look at the context, and is it, large, and is there sort of buffering, and et cetera. And, I think that could have an impact on a potential effect on neighbors. But, we are making this a bit more blunt of an instrument to do this. So I think really, these are things that we're trying to sort of work our way through, but it's hard to know when there's, these are small, relatively unique businesses. I think the most common business was still like 5% of, that was the number one sort of most common home occupation, was still only 5% of the total home occupations. So I think they are very unique and idiosyncratic to a degree. So yeah, if you have any input on what we should be thinking about, I guess, in terms of the size of or the number of clients and the number of people that should be allowed at once in particular, we're all ears.
And I guess I would follow up on that just to say, you did mention that peer review, or looking at what other local municipalities have done. Maybe I missed that part from a prior work session. Will we get to see what other cities have put into their code? If they put like a set number of commercial vehicles, have they put a set number of, clients that can visit a particular business?
Yeah, so those are both ideas that originally came from other ordinances. As far as limiting the number of clients, most other cities actually do it based on a specific period of time. So you can only have so many per hour or so many per day. The feedback from our code enforcement staff was that was really difficult to enforce, because you have to find a way to monitor that. So that's why we decided on a limit of people at one time. And as far as limiting the number of commercial vehicles, I think the most common that I remember, and I do have notes so we can distribute those, but was a lot of other cities either didn't allow any, or they only allowed one. And they weren't necessarily specific about where they were parked or anything like that. So,
Thank you.
Yeah, I guess the one thing I will say about the peer cities research is that we have a lot of information about what they do in other peer cities. We filtered it through our own code enforcement staff as to whether he thought that would be a great idea or not, but we didn't talk to the other cities about whether they thought that they worked or their code was successful or not. So, it could be that they're kind of in a similar situation to where we are now, or, something along those lines. So anyway, we weren't sure how successful they were, but we kind of got a lay of the land for what was out there, at least.
Do you have any examples of homeowners who are not running a business but have the kind of things that we have been talking about with regard to their homes. For example, multiple cars parked in their driveway or out on the street or anything like that, or noise that is going on, where there's enforceability involved in that. Do you have any examples of things like that?
No, we don't have any rules or regulations, like we don't tell people how many cars they can have. Now, where they can park it is, that can come up as a complaint and potentially a violation. So for instance, if you're not allowed to create a parking space in a required setback. That's a rule in our code. But that's not a home occupation rule or anything like that. We also have a noise, a nuisance section of the code, and noise is part of that. It prohibits unnecessary, loud, or disturbing noise, and that's at any hour of the day. And that's applicable, and we're proposing it being applicable to both home occupations, but it's also applicable if you're just a regular homeowner. But yeah, a lot of these things, these extra things that were like if we were to put a regulation on amplified noise for a business, that wouldn't apply to just a regular single-family residence unless it was found to be loud, disturbing, or unnecessary noise.
Well, I've
And
seen a
that's-
couple of
I mean-
situations where this has arisen, especially on improved streets here in Lake Oswego, where there's been an attempt to at least seemingly widen the street. And that seems to invite a lot of parking right into your place where it's widened. And then
Right.
when you're driving down the street now, it poses probably a more particular danger than it did before when it was narrow.
Yeah, we don't prohibit, residents from parking in the right-of-way, or, we do allow them to use the right-of-way in that manner. And, to the extent that, they're not blocking access or obstructing anything that needs to have, any required access or driveways or anything like that, that is something we would permit. So I think, we wouldn't necessarily, and we don't currently have the ability to really, clamp down on that type of activity other than through something like a residential parking permit program or something like that, which, we aren't considering at this moment, but we've heard some talk about. But, I think for the most part, I think I understand your point that, there are some of these impacts that we're talking about, home occupations having on the neighborhood could also, those same impacts could occur on the neighborhood just without even a home occupation being the source of that sort of particular complaint. And so I think that's a good kind of litmus test maybe to use on some of these, where we can think about, what about this is different than, why are we applying this different to home occupations? In what way is this, a different situation? And I guess I would say that the visibility of the logos does kind of present a different, a more enforceable kind of situation for staff when they go out there and sort of witness these situations, as opposed to kind of looking at each car and trying to figure out, where is that car parked, and or where are they going and what are they doing? Are they a client? Are they the owner? Are they a grandma? Who knows? So I think, yes, we're trying to, I guess we're trying to come up with regulations that would specifically kind of govern home occupations, as opposed to those more general impacts. And I do want to just point out again that we're proposing to apply just the general kind of nuisance code with noise to home occupations, so that those would be treated the same as any other noise nuisance, basically. So that is what we're proposing right now. But yeah, we I guess would be holding them to a higher standard when it comes to potential sort of impacts that the cars from their business could have on the neighboring residents.
I'd say probably the most prominent issue here is due process of law. You've got to have notice to the people who are establishing those things, and it seems like to me that you have that now. If you have to seek a permit to do that, that permit has got to contain whatever you're trying to regulate there. Because if you don't have that, I think you're going to really invite a lot of problems there among people that want to do these home businesses.
When we issue home occupations, when we issue the license, we will issue a letter saying, you're allowed to do a home occupation. Here's the standards you have to comply with. And so they're put on notice when they receive their license.
I guess I'd just point out, in addition to that, Michael has worked with some of our staff here at the city to compile the list of email addresses for all the folks that do have home occupations that provide an email address, which is most of them. So we do have this giant email listserv that he's been using, and he got a pretty good response rate for the survey, sent out the survey to all those folks, and has been, and we'll be following up with those folks in addition to all of our typical noticing that we do for any code amendments legislative process where, we would send out a notice per the state requirements, et cetera. So there will be the sort of formal official noticing, and we will go above and beyond that, I think, as well, to sort of let these folks know and continue the conversation that was started with that survey as well. So, I think, we and the business license sort of process, we have a lot of ways to cover our bases, hopefully, there.
I wonder if maybe we could go through the draft concepts so that we could remember what they are and provide feedback.
Okay. And I'm happy to kind of guide this conversation, but if you want to take control, then that's fine with me too. But starting here with client visitation. So one specific thing that we were hoping to get feedback on, like I mentioned, is the number of clients. And if there are like maybe exceptions or something like that that you feel would be necessary, that would be good to get feedback on too. So like I mentioned, the number we have right now is 5. Honestly, that was just kind of a placeholder, just kind of picked a number. Of the people who responded to the survey, most of them said that that would be okay. There were a couple of people who mentioned, actually, there was at least one that mentioned a business similar to the one that you were talking about, that said it would be more difficult. So it wasn't 100% of people who said they would be fine with it. So there's a possibility that with this specific limitation, there might be some businesses that we would be placing a hardship on.
And then I get to the thought of like, is there a mechanism where I regularly run a home occupation that I run classes for 8 kids? Can I apply for an exception? And then who decides if that exception is worthwhile or not? And you start going down that rabbit hole, I guess. And I don't know the answer to that.
Yeah, I mean, this is not what we're proposing right now, but there are, theoretically, we have discussed in the past at least this sort of type 1 versus type 2 permitting where some types of home occupations are required, for instance, in the city of Portland to notice their neighbors and go through a little bit more process than other home occupations. So that's just one way that sort of feeds into, I guess, kind of what you're talking about, that is handled, or the other cities handle this issue. But yeah, I think ideally we could come up with a number that kind of people fit under a little bit more easily so that we can minimize the need for those exceptions, I guess, too. So.
Yeah, I guess anecdotally, 5 seems a little low to me, just as a number. I guess just from my personal experience, it seems like 7 or 8 might be a slightly better number to go with. But again, I like what Eric mentioned, that City of Portland has a type 2 permit where if you regularly do something that's above the standard, you can apply for a separate type of permit that maybe then comes with additional, like you said, notice requirements for neighbors, and then those businesses may be held to a slightly higher or a different standard based on that, different level of permit. Just so we're not, that kind of eliminates a little bit of the fear of that chilling effect where somebody wants to follow the rules, but there's a hard cap, and then they say, well, I'm doing this, nobody's upset by it. If I give notice to my neighbors, I can still be compliant with the law, and also maintain the character of the neighborhood.
Yeah, I think that's certainly something we can consider. We did identify a number of concerns, I guess, when we did talk about the type 2 notices. So I think I think maybe there could be another way, I guess, to get there. But yeah, I think we will look into, I guess, first of all, what should the number be? And then I guess what we can do is come up with some concepts for folks that might exceed that number for allowing them to continue their business and what that would look like. That makes sense. I think particularly you had mentioned schools, I believe, as one thing that, might have up to, 8 children maybe at a time or something like that. So maybe that's something we could focus our research on, just kind of the specific needs of, not necessarily quote unquote daycares or, licensed schools, but just kind of classes or people that do, instructional kind of things that maybe aren't all day long, but just, a couple hours a day type thing. So anyway, that's at least something that we can sort of hone in on and try to understand the needs of a bit more.
Thank you.
Yeah, I think in some ways this seems like a difficult concept because numbers could fluctuate a lot in ways that would not be significantly different from residential use. Like just, an example that would come to mind is, let's say you're maybe like a financial planner who you work out of your home, and one day a year you have like a client event where you invite all of your clients to a party in your backyard. Now, that's not significantly different in impact than, a normal person having, a larger party one day a year. But, that could be, look like a large number of people, a lot more than, you're having on an everyday basis. So, maybe some sort of process like we're talking about where maybe you can give notice and, get some sort of exemption for an event.
Well, it's interesting. I mean, just in that scenario that you, that fictional scenario, if someone was just putting on a party and invited clients, I would say that's their personal, they're using their home, like they're just having a party. Unless the clients are paying to be there, I would say that's not a business activity. But, I'm sure there are situations where somebody could have an event that the clients would be paying to go there. So your point is well taken. And, the other thing is when we were looking at allowing some outdoor activity, limiting the number of clients was sort of a proxy of trying to, diminish the potential impact to the outside, because if you have 20 people in your backyard versus 5 people, that has significantly, potentially fewer impacts. So I don't know, maybe we don't have to regulate the number of clients that come there if we're already not going to allow outdoor activity. I mean, if it's contained inside, I guess the potential impacts would be parking and traffic. That would be the impacts to that.
I think that's a good point, though. I mean, we might want to consider whether this is needed still, if we're no longer, allowing outdoor activity or only, allowing that with certain exceptions. The noise issue will be covered by our noise provision here. The parking issue with commercial, cars at least will be covered by our sort of commercial vehicles provision. So is this necessary? I think is another question.
Well, or could that be hybridized, like a limit on the normal number of clients outside, or, number of, client vehicles, right? Like, try to hone in a little bit more on the.
We did try to think of client vehicles, and I think almost immediately realized that would be impossible to enforce.
We don't know whose vehicles they are. Like,
yeah, but no, I mean, that's certainly what we're thinking of for sure. And I think, I think limit on the number of clients outdoors might be something that we could talk about, because that's really kind of what this was meant to get at, I think, originally when we originally drafted it. So.
If I can offer a suggestion, I think kind of the gist of what we're trying to get at here is to make sure that there's a balance of the home businesses not having their rights more limited than the homeowners nearby. For instance, a homeowner could throw a wild pool party every weekend, and the home business isn't able to do a silent yoga meditation class outside. So I think that's part of where this tension comes in, is it is so situational, which is exactly why we're looking at this code, because it was too interpretive. But I don't know if there's a way to still build in some flexibility to, or maybe that it'll just be like part of the annual code amendments. A situation will come up and we have to say, okay, write in that you can have your silent outdoor yoga meditation.
I mean, that is kind of where we're going with this clear and objective criteria, I think. But I think that, just to kind of go back to what you were originally saying, just the idea of, wanting to make sure that we're not necessarily treating home occupation businesses differently than we would a typical resident. I think that's a good, I think that's a good sort of thought exercise to go through. I do think that there might be some instances where you might think you would treat a home occupation business a little bit differently, but and I'm not sure we would actually allow loud pool parties every single weekend for a normal residence, but I don't know. Maybe it's a gray area.
Well, and there's a difference between having, a loud pool party every weekend versus renting your pool out 5 hours a day, 7 days a week. That is, believe me, we've had to deal with that, and it was a horrible mess that
aware of the
went
business
very up to
model.
high level, and it was extremely difficult to enforce. So
Yeah.
I think that's where there's just too much gray area, and it's really hard to enforce, because you go out there and it's like, well, who's a client, who's a friend, who's a, and then, and oftentimes we can't go on the site to verify those things, so we have to view it from off-site to even enforce it. So it becomes very difficult. And we just had a complaint about someone doing outdoor exercise with a group. So that literally just came in the last probably 2 weeks. So people still complain about that.
So you actually get called on these things? Calls come into you?
Come into the
How does
the
it-
city
how-
call line, there's a front desk, and they sort of, direct the calls accordingly, and then, when they hear that, they would direct it to code enforcement, and which is in our Department of Community Development. So we hear about it. Jessica didn't herself receive the call, but we know about it because our staff did.
I supervise the code enforcement staff, so I get involved in these quite frequently.
I'd say, it seems to me, and I don't want to speak on behalf of anyone individually, but this is the second work session now, and I recall the first work session, and I get the sense that everyone's a little uncomfortable with moving past the standard for reasons that everyone's pointed out, particularly Rachel, your point about, we sort of quote unquote banning something just because it's part of a business, right? Whereas homeowners could do it regardless. And I think Jessica made a good point when we talked about it last time, which was like, we are. I mean, there's no doubt that we are, because for the most part, folks aren't going to have a party every day, all day, but a business generally needs to run every day, all day, right? And obviously, I'm generalizing, but I think it's the frequency which businesses would have 8 people outside doing an outdoor class. A business owner is there to make money, so they'd want to do it 5 days a week if they could, right? Whereas the person who's going to have 8 people over just working out probably won't do that 5 days a week all day. And I feel like that was the reasoning for treating it even differently, but I had the same discomfort. So all this to say, like, I think we all generally are like, kind of want to go keep the standard as vague and nebulous as it is, because we're getting into the things that it wouldn't make sense to adopt, like a art teacher who's teaching 8 kids outside, like we're going to chill that. But, we're here, I think we're here because code enforcement said, like, I can't enforce the statute as it is. We got to do something about it. And then when you were in front of city council, it seems like city council is on board with doing this as well. So, I'm not saying we have to just accept it, and I think in theory we could come and say we don't want to do it. But I think that's just important to keep in mind, is like the balance is what we've been directed to do from staff, from code enforcement, and from city council. And we are going to cut off things that probably are like, why are we cutting these off? And then if we have a whole path for exceptions, well, then we're almost back to where we were, where there's like, if there's so many exceptions, then we're back to just what's the character of the neighborhood statute. So I feel like I agree with everyone here because I've had the same sort of complaints, but I think we gotta either focus on giving something or we gotta decide like we don't like it.
And of course, we want to get the code right. And it's an art. It's not a science. I'll tell you, I've written a lot of code and you think you've got it, and then somebody will interpret it differently, or you didn't think of a certain situation. It's never, ever perfect. And that's why we have our annual community development code maintenance that we do. So we can, once we implement something, we just remember that it doesn't mean it can't be changed or modified or, finessed later on, which happens a lot with code, which is why we have our annual maintenance process every year. So, but yeah, we do want to try to get it right as to the extent possible. So your feedback is really helpful and important. So thank you.
And when we get the draft, the next work session, we're gonna have the chance to talk this all through again, and at that point in time, make the recommendation. So just saying 5 or 8 clients at a time today, like we'll have the chance to revisit that.
Yeah, I think, if you had any areas that you want us to look into, I think, the idea of looking into like a school and how many, people would be at that school is, or at those types of home occupations is a good kind of thing that we can look into. But ultimately, we are going to be, per council direction, bringing you a set of draft code amendments, and you can adopt them all. You can, or recommend to adopt them all. You can recommend just a few of them. You can, choose your own adventure, I suppose, as a commission. But, I think what we're talking about right now is what to put in those draft code amendments to bring forth in the first place. So, yeah.
Any other feedback on this one? I think what I'm hearing is might want to look into increasing the limit, maybe having some sort of type 2 where if you go above a certain number, you can maybe do it if you meet some additional criteria, maybe getting rid of the limit and just applying it outside. It's kind of the feedback that I've taken down. Okay. All right, so the next concept had to do with commercial vehicles. And so like we discussed, the council thought commercial vehicles that were parked on the property should be fine, but perhaps we should consider a limit on the number that are parked off the property, and they suggested a limit of 1. Again, the enforcement based on visible logos was just for the ease of being able to tell whether a vehicle is associated with the business or not.
This one seems good to me because it's so easy to measure. It's like there's 1 out there and you're good. There's 3 and you're over the limit. And that's, and it's been a complaint. People have actually complained about a lot of commercial vehicles parked on the street. And so I guess this one I like a lot more just because it's easier to measure. And then it's just a trick of getting the right number.
And the survey results that there was very small amount that said this could be an impact?
Yeah, so there were 153 respondents total. I think of those, maybe 12 said that they had non-personal vehicles. The way that the question was worded, I think a lot of those people, in looking at their answers, a lot of those people interpreted it to mean client vehicles. So there were probably 2 or 3 businesses of the 153 or so that said that they had a commercial vehicle. Like I said, of those businesses, they said they either had 1 or 2. They did not tell me whether they parked it on the property or not, because I didn't ask. But yeah, so that gives you a sense of the sample we have, that's who would be impacted potentially.
So are you looking at a particular number here?
1. City council said 1.
That was in the draft code that we have right now. Was 1 could be parked off the property, and then we'd have no limitation on the property.
Yeah, I'm with James. This is objective. I think this is something that does affect neighbors with the parking, and this is something at the top of their mind. And based on the survey results, which I really, really appreciate the survey results, it doesn't, we didn't have a large number or even a medium-sized number of folks coming out and saying, I have 4 commercial vehicles and I'm not going to be able to run my business this way. So I'm comfortable, city council has given us 1, I'm comfortable with that.
And the safety valve of, if you can use your own property
Yeah.
to put your vehicles, this is a, pretty baseline, not too harsh restriction, I think.
Okay. There's no other feedback on this one. I'll move on. Okay. So, in regard to outdoor activity, so when we talked about this in January, I think the commission's feedback was that you wanted some flexibility on this. And the council kind of felt the opposite, that it wasn't in line with neighborhood character or what you would reasonably expect for a home occupation business to have outdoor activity. So their suggestion was to go back to the idea of just banning it altogether. Like I mentioned, we have considered whether we should include possibly some exceptions for things that we know probably wouldn't have a huge impact on neighbors. The example I gave was a commercial artist who's just painting in their backyard. So if you have any thoughts about this one, any ideas for exceptions, that sort of thing that come to mind.
It seems like outdoor activities would often fall, I think like Eric said, under general nuisance laws. Like if you're doing something stinky, like that's going to cause people to be upset. If you're doing something really loud at night, people are going to be upset. But those fall under normal nuisance laws, right?
Yeah, we have the hazardous materials code provision as well, so that's another way that we could cover that. So generally, yes, and I think a lot of times when, I think because the existing provision we have right now, that sub-criterion 1 is so subjective and broad that, you could argue right now that it is governed by a sub-criterion 1, but if we take that out, then it would, I think, be more clear that it's not. So yeah, I think generally speaking, if we want to come up with our own specific regulations for outdoor activities that can be governed, in terms of time of day, or I think we talked about the size, of the space that it's taking up, but potentially the number of outdoor clients. That's one thing, but I think, yeah, certainly there are a number of other just base nuisance provisions that could get at a lot of the impacts in the exact same way.
I think that verbiage right there is overly broad.
My verbiage
No,
or outdoor, yeah, that is not what we propose in terms of the draft code. It just says no outdoor activity is allowed, basically, for the home occupations. But the possible exceptions piece there is because we did, want to bring that up and want to, insert that into the conversation. We had that council study session on April 1st, and we had to get this study session, the work session materials out just a couple days after, so we did not have even close to enough time to kind of think of all the different exceptions. We did not initially propose just to ban outdoor client activity. So we do propose to come at the next work session and talk about what those exceptions could be.
Did city council identify certain activities that they thought were problematic instead of the opposite, identifying things we want the exception? Did they talk about things they didn't want happening?
I think, certainly the group outdoor parties was definitely a thing that they didn't want. And I think outdoor exercise with amplified sound was another thing that they didn't think was appropriate. I don't know. I'm trying to think if there were other things that specifically were mentioned, but I think the majority of council, at least, I think, indicated that those things were a concern.
Yeah.
I guess what I'm curious is then why wouldn't those things be covered with a time of day limitation and also the noise and nuisance laws that are in place? Hoping this is under possible exception, but like short-term rentals, you can't really tell someone you can't go have dinner on the back deck. Like,
No,
it's
that-
not
Yeah,
enforceable.
that's not what the intent is, and that, yeah, we definitely need to carve out something for that. Short-term rentals are a different type of a home occupation. But I can tell you this, that we've had a ban on outdoor activity for almost 2 years now. Been just fine, if I'm being perfectly honest with you. It has worked. I mean, it actually has eliminated a lot of the worst problems that we've had to deal with. I'm not saying that it couldn't be a problem or that we shouldn't think about these, exceptions. I mean, clearly, one of the big ones that came up was daycare, but then we realized, well, the state doesn't allow us to restrict daycare uses any more than a single-family dwelling, so they're fine. But yeah, then we start getting in these gray areas of the agricultural uses and things like that. So I think we can look at those exceptions, but there's a lot of innovative business out there. You can rent out your patio for events. If you've got a beautiful patio on the lake and a beautiful property, you can rent those out for events. You can rent out your yard. It's called Sniff Spot for dogs to come. You could have a dog kennel or boarding facility, and I have a neighbor in Portland who does that, and I could tell you it's very impactful. Or the Swimply type situation where you're renting out your pools and whatnot. So there's a lot of innovative businesses, and while we don't want to, stifle business here, we also have a lot of people with a lot of beautiful properties that could have a lot of events that could be impactful to the neighborhood, and those are super hard to enforce and resolve under the current criteria for sure.
Yeah, and just to be blunt, we have a lot of people that are prone to complain about those things because they have a very nice, large, expensive property next to the one that could be having a party, so.
And if we're looking at limiting the number of clients, I mean, and I know that's just a concept at this point, but that would also restrict having a huge party because you've got 8 people cap.
Yeah,
Do dogs count as clients?
I think what I'm hearing is that, we're feeling that this concept might not be targeted enough. Even what I'm hearing, and feel free to correct me, is that there would be a preference for targeting it more specifically rather than carving out exceptions. Because then we'll have to think of more exceptions. Am I correct in saying that?
Yeah, good summation.
Yes. Yes. I think, sorry, Eric. If we're going to have 8 people max, then why can't we let the 8 people be outside? That's really my thinking. Like, if we're having 8 students painting, nobody cares. So if we're going to come up with a limit, then I feel like that's going to take care of almost all the problems combined with the noise. It still can't be a nuisance, right? You still can't have amplified sounds. On the other hand, if it's already a policy, and to Jessica's point, it hasn't really been affecting anyone for 2 years, and it is already a policy, then why wouldn't we codify it to make it clear, right? So,
To play devil's advocate, right? So our current policy, or our current code is extremely subjective. If you're a home occupation, you might think, I could do an outdoor activity and still meet this subjective criteria. Our policy doesn't come into play until there's a complaint, and we're out there trying to figure out how to enforce that complaint. And that's when we say, actually, we have this policy that says there's no outdoor activity allowed, so you don't meet this criteria. But that's not the common understanding of this. Oh, it is a condition of approval for all home occupations? Okay, well, I think it becomes a little bit different when you put it in the code, I guess is my
Yes,
point.
yes.
And it becomes a very known sort of line of demarcation, both for the residents and the neighbors that could be issuing the complaints. So, yeah, I think it's not a current standard, and we would be, sort of advertising that, making that a little bit more known than it is currently, I suppose.
I guess we have a decision to, direct, like, come back with us with the ban in there as council has said it, or, and we could talk about it then, and that's the time to deliberate, or do we want to, do we want to just be like, if you're going to cap it at 8 people, then we recommend getting rid of this ban altogether? And I think that's something we don't have to decide today.
Right.
We decide when you come back with it.
I will just strategically mention that, we do get the impression that council very much wants to keep this ban on outdoor client activity. So it might be persuasive, maybe more persuasive to say, to put some exceptions and say, we think these are more reasonable things that we should allow, as opposed to having sort of an entire framework where, we are governing this through different standards where this isn't necessary, because they might just say, no, we want to do this. I guess I'm just saying there's an art to this, and maybe if we don't think that this is appropriate, the exceptions might be more persuasive eventually or something. But it's up to y'all. But I think what we're hearing from you and what we've heard from a number of people is, we don't want this to negatively, adversely impact existing home occupations. And so I think that's something that we will continue to convey and try to craft regulations to reflect that.
That could
I think
also
we're
be
talking
part
about
of
alternatives maybe too, and maybe we have exceptions, maybe we have other things that we have that don't require exceptions. So anyway, sorry.
Sorry to interrupt you. Part of a level 2 application, if that concept does get more traction, is you want to have outdoor activities. That's something that requires a level 2. And then you can pull the level 2 if somebody's abusing that and neighbors are complaining and things like that, right?
How does the commission as a whole feel about this? I think we talked about this a little bit. This is a type 1, type 2. I guess I'm trying to gauge how much time to spend on that concept and how much to flesh that out, because, that could be a way to keep this ban on outdoor client activity and allow for that release valve, I suppose, that you were talking about.
How burdensome is it on staff?
I think that's probably most of the pushback was when we talked about actually how to implement this. But let's say we'll look into it and study it, and then we'll come back with some type of
Did you
summary
have
of what we
in mind
find.
when you said client activity, a particular thing there? I mean, how would you define client activity?
It'd be activity associated specifically with the business. So if someone is a Pilates instructor and they hold their Pilates classes outdoors, that would be a
So it has
client.
to be related to the business.
Has to be related to the business.
So if you had a party for all your clients and so forth like that, you wouldn't be aiming at that.
No, or you just had a party with just for your friends or whatever. Obviously it's still your home, so you can still treat it like a home. But if you're using it, if it is a sort of a paid activity that is part of your business, then that would not be able to happen outdoors, recognizing that there's some exceptions that we need to look into. Because again, if someone's an artist and they're painting outdoors, oh my goodness, I can't imagine anybody even complaining about that, but you never know, you might get a neighbor that doesn't like you. So we want to make sure that we have some bit of a relief valve. And of course, we should explicitly say it doesn't apply to daycares, maybe
So if
agricultural.
I was selling wine out of my home as a business,
You can
and
do
I
that.
had 5 clients or 6 clients sitting there drinking wine, would that be a problem?
It depends on where we land, I guess.
Up to 8.
Yeah, I mean, if we say that you can have up to 6 or 8, then yeah.
As long as they're quiet.
Yeah, I think just to mention, we did kind of flag that there is an existing winery in the city, or maybe a vineyard, I guess is more accurate. I'm not sure if they actually make the wine on that property, but they grow wine grapes rather, and they sell and have the wine available for consumption on the property. And we know that exists, and we know that these regulations that we're talking about could potentially, they wouldn't fall under the regulations that we're proposing necessarily here. So, I think they're talking about 10 to 15 people could be there at any given time. So that's part of why we're proposing this alternate path for that type of use that we're going to flush out a bit more before the next work session.
Thoughts on, I think we have some direction that we can work with. Okay. All right, so on this one, we don't necessarily need a ton of direction unless you have strong feelings about it, but just to reiterate, we took this concept of possibly banning amplified sound or like certain types of speakers, and just turned it into including a reference to the existing nuisance code to make sure that people were aware that that was something that would still apply to your home occupation. So as long as everybody's comfortable, I'll move on. Okay.
Well, I like the flexibility for, the home business owner that, this updated idea brings in. But I wonder if it might bring back some of the same enforcement problems. Okay, it's unnecessary. Well, the business owner thinks it's necessary. I mean, these are things that get litigated.
Right, so I mean, that's exactly why we wanted to reference the existing nuisance code. So there's a pretty detailed section of the city code that spells out exactly what sort of conditions need to be in place for the police officer that's out there sort of responding to the incident to determine that it is in fact a noise, that it rises to the level of a nuisance. And there are pretty I mean, that's exactly why we wanted to do this, because there are very specific, detailed sort of outlined standards, or I'm not sure they're standards, it's code that defines exactly when it is a nuisance. And, it's not just somebody saying, I think this is necessary for my business or not. It's, the police officer has to go to the adjacent house where they heard the noise and be inside the house and be able to pick up that noise. And there are a bunch of other criteria that need to be met. So it's not a subjective process, I think, what we're proposing. That's not the idea, at least.
Okay.
Yeah.
And so essentially it's how would I say this? Would a police officer respond to this if it were known to be business related?
That is what we're attempting to stipulate in the code, that it would be handled that way, yeah.
It could be the code enforcement officer too. They both respond to it now. It just depends on when it happens. So, but yeah, either our code enforcement staff or the police could respond to that. And because it's such a common complaint, they're pretty good at dealing with it because it's one of the more frequent complaints that we receive.
Mm-hmm.
Yeah,
So
I guess regardless of who's doing it, would be the city code that sort of talks about specifically the definition of a nuisance. And
So
for
it's
noise.
essentially making, noxious, activity that is already prescribed also a violation of, the home business license. Like,
clear that it applies.
Yeah, we're essentially saying, hey, this also applies to home occupations.
and would that mean like, okay, this happens, would that be grounds to like revoke the business license?
I don't know. We've never revoked a business license because of this. Like I said, our first, the first thing that we want to accomplish is voluntary compliance, and we almost always get that. Then we will escalate to a civil violation, and then or a violation letter, and then to a citation. Sorry, that can go to court, and it is actually enforceable per incident. So it could get real expensive if they keep doing that. So it usually can be resolved by itself. We've never gone to the level where we had to revoke anybody's business license. But I think what we're doing here is we're saying instead of coming up with this additional standard on banning amplified sound, today our existing nuisance code applies to home occupations. We can apply that. This will put it in the standard, just referencing it, just so it's crystal clear that that's how we're going to enforce it. Rather than adding this additional ban on amplified sound. It's like it's easier for us to just stick with our existing nuisance code.
And would I be correct in saying that, the business owner could, combat a claim like that in the same way he could, a homeowner could if someone had an issue with what he was doing? He's like, no, I think this is fine. So I think that would be a positive element to this as well.
Yeah, it would go to, court potentially if it rose to the level of a citation, and yeah.
Okay. So the next idea had to do with delivery trucks. Like I said, We proposed possibly banning like semi-trucks or tractor trailers. Council did not find that to be reasonable. From what I remember from the first work session, this wasn't a particularly popular idea at the commission either. But again, if this is something, I guess the only feedback I would be looking for here is if there's anyone who like desperately wants us to stay in, then okay. Otherwise, we'll continue with keeping this out.
Don't want to get into the business of counting axles, I guess, too much.
And then similarly with the flag lot restrictions, this was something that the council directed us to take out. So as long as everyone is comfortable with that, then okay. And this is the last one. This is kind of similar to the nuisance code reference. It basically just references the state definition of hazardous substances and makes it clear that you cannot have a hazardous substance on your property with your home occupation as defined by state law.
This could be a very niche case, but I'm envisioning, say someone is running a laboratory in his home. That might be a problem, right? I mean, I assume some things that would be, used in that kind of setting could be noxious, hazardous.
Yeah, I think it's kind of a matter of like what type of laboratory uses we feel are appropriate within a residential neighborhood. And so I think that was I guess, kind of where this came from. I'm not sure if this is banned so via state law anyway, or if we're just kind of mentioning that. But yeah, I think we could do a little bit more research into what type of businesses might need to use these hazardous substances.
I'm wondering if it's necessary, considering that we're already wrapping in the nuisance stuff. Okay, you have a hazardous material outside, it's causing some sort of problem. Maybe there are fumes or, I don't know. But, if it's, contained in the proper way, if it's legal indoors, is it necessary to, ban that?
I think, I guess, again, maybe devil's advocate, maybe you wouldn't want to take the same risks, I guess, in a purely residential neighborhood of people handling those materials and, unloading and loading them. And just, I guess the potential sort of risk of that type of activity could not just be limited to smells and noises, I guess. I think that's kind of the idea here.
And there could be fire code and building code regulations that come into, particularly if someone is, using heat or pressure and hazardous substances. I mean, it can be explosive, it could be actually quite dangerous, and that actually could violate building or fire code requirements as well. So, I think the idea is like those types of activities probably shouldn't be happening in a residential neighborhood, which is why we went to so these are not just your typical household chemicals. These are more hazardous, toxic materials. And there is a definition here as being toxic, corrosive, irritant, strong sensitizers, flammable, combustible, or generate pressure through decomposition, heat, or other means. And it specifically references ORS Chapter 453. Hazardous or substances or mixture of substances may cause substantial personal injury or illness during or as a proximate result of any customary or reasonably foreseeable handling or use. So we aren't really talking about like household chemicals type stuff here. But again, if you all have feedback on that, happy to take it. And this was common in other jurisdictions? Is that what you found?
Yeah, there were several other cities that had a ban on hazardous materials, and it was something that our code enforcement staff suggested adding.
I have a question. Do we have restrictions on hazardous materials for non-business use? Because I can see someone having a business that uses them, but what if they just have a hobby that has dangerous materials? I'm curious if we have anything that restricts that?
That is a good question. I don't know. My guess is that it is the responsibility of the individual to assure safety, but if you have a business where this is something that's, constantly operating, I think that's when our fire and building code comes in. But if it's a hobby use, I don't know.
I mean, I know like on 4th of July, I can go buy a bunch of
Yeah.
really explosive stuff and keep them in my garage, and I can even, light them on fire at certain
Right.
times, and it's legal. But this would make it not in line with the business, home occupation standards. So I think Commissioner Rigby has a pretty good point at this point that, maybe this doesn't belong here because it's regulated elsewhere.
Well, we can look into that further. I mean, certainly if you were manufacturing fireworks, I think that would be. But if you're purchasing them, I don't know that that is going to be enforceable. I don't think that's what this is getting at. But yeah, we can look into this further. We can talk to our fire marshal and building official to get a little bit more direction and provide some more information for the commission.
Yeah, I'm quite sure you're not allowed to do things like dumping hazardous material on your property, but I'm not sure how much it's assumed that if you have them, that you might dump them or spill or something. So yeah, we definitely can look into those details.
Well, and like you brought up, Jessica, their fire code, there are existing codes that, might target some of the handling aspects here. So.
So this was the last concept. I think that's all the feedback that we need. Like I said, we will, on the agricultural uses, we'll come back with more on that in the next work session. But unless anyone has any last thoughts, I'll say thank you for your time and your feedback. And this has been really helpful.
Thank you.
Thanks.
Thank you.
Okay. Item 8, other business. Do we have any other business?
No, I just welcome Commissioner Bruce again.
Item 9, schedule review.
All right, so yeah, coming up at our next work session will be April 28th, so 2 weeks from today. Director Numonolu will be giving us an update on the 2025 Oregon State Legislative Session, particularly kind of what bills are likely to pass, what bills have gone away for now at least, and kind of how that could affect our work here at the Commission. So we'll learn a little bit more about that. May 12th, I might just actually cancel that one. We don't have that much going on at the beginning of this year. We have a bunch of stuff that is going to get slammed into the end of the year, unfortunately. So we might want to just take this luxury that we have to not meet on that day. But anyway, if something comes up, I will, of course, program that, but leaning towards maybe that being a cancellation day. On the 28th, we have a full schedule, of course. We have a lot of projects that I'll be touching in on as part of the larger implementation of the housing production strategy and an update on that. So it looks like, I think there's 1, 2, 3, 4, 6 or 7 different projects on here that looks like we're going to be covering. It's actually just one item, but going to cover a lot of ground with that one item on May 28th. So that will be a longer meeting there. And then on June 9th, we, as Michael mentioned, we'll be having the next home occupation work session, the third one, where we'll be coming back to you with some research on what you had talked to us about tonight and some of the topics that you had identified, in addition to a little bit more refined kind of ideas on the agricultural uses and how to govern those. And yeah, that brings us at least through the beginning of June. So yeah, thanks again for Commissioner Bruce. Good to have you on board, and look forward to seeing you all in 2 weeks.
Thank you, Eric. And with that, we're adjourned.